Dr. Vijaya. My name is Saasha, and today I'll be discussing how rigid the courts have been in assessing testamentary capacity. My analysis of the court's assessment will focus on the common law jurisdictions of England and Malaysia. A person executing a will in Malaysia must adhere to the rules outlined in Section 5 of the Wills Act in order for it to be valid and effective. These requirements are: the testator must attain the age of 18 years old in accordance with the Age of Majority Act. The testator must have a testamentary intention that is voluntary and informed. The will must be in writing and signed and witnessed. And the testator must have testamentary capacity. Testamentary capacity refers to the mental capability to execute a will. Unlike some of the other requirements, testamentary capacity is a much more complex matter to be considered. Section 3 of the Wills Act tells us that only a person of sound mind can execute a valid will. Section 51 of the Mental Health Act defines a mentally disordered person as any person found by the due course of law to be mentally disordered and incapable of managing himself and his affairs. The current and relevant definition of a mental disorder can be found in Section 2 of the Mental Health Act, which states that a mental disorder relates to any mental illness, incomplete mental development, psychiatric disorder, or other disorder or disability. The common law test for testamentary capacity can be found in the 152-year-old landmark case of Banks and Goodfellow, and is upheld in most common law jurisdictions to test whether a person was of sound mind at the time the will was executed. It is a cognitive test based on things pertaining to understanding and knowledge. For a testator to be deemed of sound mind, they must fulfill these 4 essential elements. Firstly, the testator must appreciate and understand the consequences of making a will. It should be highlighted that in assessing testamentary capacity, the court does not necessitate a detailed understanding of the legal wording in the will. A general awareness of the will's effects, such as what the beneficiaries will receive, the fact that the will only takes effect after their death, and the fact that it can be revoked is what is crucial. Secondly, they must understand the extent of their property. The courts do not require the testator to have an extensive and thorough breakdown of his assets. It only requires a general understanding. Thirdly, they should consider the potential beneficiaries who have a moral claim upon them. This includes individuals they would generally be expected to provide for. They should not have any delusion or mental illness causing them to choose not to benefit them. This was seen in Re Ng To Pew, where the testator was oblivious to his son's claims due to his deficient memory caused by mental illness, and it was his deficiency in memory that caused him to say to one of the witnesses that he had no son. The court therefore pronounced the will to be invalid. And lastly, they should not have a mental disorder or insane delusion which has affected their testamentary intention. The issues to be considered when deciding mental illness is the severity of the mental illness must be such that it negates the conditions in Banks and Goodfellow. And secondly, the timing of the mental illness must apply at the time the will was executed. What the law primarily looks for as vitiating mental capacity is mental disorders such as insanity or delusion. If the testator is eccentric or subject to one or more delusions, it is not itself sufficient to invalidate the will. It must be shown that delusion or insanity had an effect on the testamentary dispositions. The reasoning behind this is because most patients suffering from mental illness or any subnormality seem to still understand the nature of a will, namely that it is a document which disposes property on the death of the testator. In Banks and Goodfellow, the testator clearly suffered from a serious mental disorder, but was nevertheless deemed capable in respect to the execution of his will, as it was held that his delusions did not affect the distributions of his assets. However, if the delusion overrides the judgment and rationality of the testator, it will render the will invalid, as seen in Dew and Clark. In the Malaysian case of To Yau Pew, the High Court held that the testator did not have testamentary capacity. However, the Court of Appeal ruled that the law requires very slight testamentary capacity for the making of a will. What the law requires to vitiate testamentary capacity was an insane delusion existing at the time of the will being executed or at the time of giving instructions for the will to be made. It was held in both Lee Ing Chin and the case of Sendambal Durayapa that the mere fact of bodily ill health or imperfect memory is insufficient to vitiate testamentary capacity. From these cases, it can be seen that Malaysian courts are strict in determining what severity of mental illness can actually vitiate testamentary capacity. It was also shown that testamentary capacity is not to be equated with contractual capacity, as a person may lack the mental capacity to enter into a contract and yet may have sufficient testamentary capacity. The trial judge in the relatively recent English case of Sharp and Adam indicated that there may be a requirement that the testator have a rational, fair, and just will. Nevertheless, the court held that this did not alter the elements contained in the Banks test. In Smith and Smith Trustees, the testator's will was challenged due to his incapacity, and although the court determined that he suffered from delusions, it had no impact on the terms of his will. The testator's delusional belief did not invalidate his testamentary capacity, as having irrational beliefs is permissible as long as it does not affect the conditions in Banks and Goodfellow. Additionally, a testator may exhibit lack of testamentary capacity, focusing on a specific person or piece of property. The specific portion of the will that was impacted by the testator's delusion could be severed from the rest of the will, as seen in the English case of Estate of Borman. The relevant and material point of time at which the mental capacity of the testator needs to be determined is the time at which the will was made. If the will is challenged on the grounds of unsound mind, the court will be satisfied on a review of the whole evidence that the testator was of sound mind, memory, and understanding at the time of its execution, or that the will was made during a lucid interval. A case that illustrates the leniency of courts in assessing soundness of mind is Chamber and Yatman. Here, the court admitted an application for probate to a will made during a lucid interval, even though insanity had returned the next day to the extent that the testator had killed himself. In Nisbet's Trustee and Nisbet, it was held that a person can recover from mental illness and still draft a valid will. Even though a testator is frequently of unsound mind, they are nonetheless capable of executing a valid will under a lucid period. Similarly, in Anguilla and Rahim Abu, although the testator was physically frail and dull of mind, both doctor and lawyer attested that they witnessed him being of sound mind, memory, and of understanding. From the facts, the court determined that the will had been drafted during a period of clarity, and therefore he had testamentary capacity. However, there is an exception to the general principle that the testator must be mentally capable at the time the will is executed. It was illustrated in the English case of Parker and Felgate that when instructions are given before the execution and the testator loses testamentary capacity, between this time of instruction and execution, the relevant time would be when the instructions were given. Two conditions must be satisfied for this rule to apply. The will was prepared in accordance with the testator's instruction, and at the time of execution, he understands that he is executing a will. The court will only apply this rule when there is no grounds for suspicion. This exception is one more reason why courts are seen to be lenient in validating wills. The precedent law in Banks and Goodfellow only requires the challenger to raise real doubt regarding the testator's testamentary capacity. However, the burden of proof is on the party propounding the will, who must then prove that the testator had the necessary capacity. This is similar to what is upheld in Malaysian law, as seen in Udam Singh and Inder Kaur, whereby the burden of proving testamentary capacity rested on the person alleging the validity of the will. In recent times, the Mental Capacity Act was implemented in England, which addressed many facets of how mental capacity should affect decisions being made. It has been argued that the test in Banks results in a lower test for capacity than that prescribed by the Mental Capacity Act. The statute requires a person to be able to understand all information relevant to the making of a decision, and the person must be able to retain that information. In contrast, the common law test does not require the ability to remember and understand all the relevant information. To put an end to this debate, the court ruled in Clitheroe and Bond that the Mental Capacity Act does not extend to determining where an individual had mental capacity to enter into a particular transaction that he or she had entered into. It was confirmed by the judge in this case that the test in Banks and Goodfellow is still good law, although the Mental Capacity Act can still be considered in conjunction with the test. Academic scholars have pointed out the stagnation surrounding testamentary capacity and have made calls for reformation. It should be highlighted, though, that the courts have become less rigid in assessing testamentary capacity since the ruling in Banks and Goodfellow. Previously, in cases such as Smith and Tebbit, the court had laid down that any degree of mental unsoundness, however slight and however unconnected with the testamentary disposition in question, must be held fatal to the capacity of the testator, which is indeed a much stricter approach compared to the current law. To add on, the golden rule was laid down in Kenwood and Adam, whereby a lawyer should ensure that in the event of any doubt, a will should be witnessed and approved by a medical practitioner who had satisfied himself of the testator's capacity. Although in Sharp and Adam, it was stated that this rule is not mandatory and it is only good practice. This once again shows the leniency of the court, as it does not require any medical proof in its assessment of testamentary capacity. It has also been propounded that the level of cognitive ability needed to create a testamentary instrument strongly correlates to how complicated a testator's affairs and testamentary wishes are. In other words, the more complicated the action, the more cognitive function that is needed. To determine testamentary capacity, the court must rely on evidence such as observations of the testator's behavior reported by neighbors and friends, medical evidence from the time of the will execution, and the content of the will itself. Therefore, the court's judgment will be case-specific and correlating to the complexity of the testator's affairs. This shows the flexibility practiced by courts in assessing testamentary capacity. However, this flexibility has been criticized, as it can be said that these uncertain assessment standards and procedures lead to unpredictable outcomes. It has been argued that due to the advancement of medical and scientific knowledge, without a matching advancement in the evolution of the test of testamentary capacity, a significant number of wills that should not have been probated were in fact admitted to probate. The test in Banks and Goodfellow may still be an applicable baseline. However, there needs to be a recognition that medical technology has advanced and our lives are much more complex than they once were. For example, how can a testator understand the nature and extent of their estate given the complex estate planning mechanisms that can be used today? Furthermore, is a test from 1870 adequate to assess testamentary capacity given the increase in mentally disabling conditions such as dementia as a result of the test's low benchmark for testamentary capacity? It is possible that an individual may have dementia and be unsure as to the date and location and yet still meet the criteria under the Banks test. In conclusion, the courts have only been rigid in regards to asserting that the primary foundation in assessing testamentary capacity should still be the test in Banks and Goodfellow, despite societal and medical advancements. However, other legislations are allowed to be considered alongside the test, such as the Mental Capacity Act, and for Malaysian courts, the previously mentioned Wills Act and Mental Health Act. Due to the low yardstick in the common law test, we can draw the conclusion that courts are rather lenient in assessing testamentary capacity. Nevertheless, the court's main aim in assessing testamentary capacity is always to verify the intent of the testator, while also to protect their families from testamentary acts of mental incompetence. And that will be all from me today. Thank you for listening to my discussion.